I'd like to welcome everyone to the Nashville Bar Association Judicial Town Hall and welcome Judge McClendon, who presides over the Second Circuit Court in Davidson County, who has graciously agreed to be with us today to talk about how things have changed in court operations in light of the COVID-19 pandemic. Judge McClendon, welcome.
Thank you, and Laura, thank you for inviting me to participate. It's a welcome reprieve from what my days have become the past 6 weeks.
Yes, I think everyone looks forward to seeing each other's faces, even though we can't be in person.
Right.
I will start with just a broad question. I know that you handle a number of different dockets in your court. Can you give us a general overview of how those different dockets are working right now?
Well, right now I still do hear civil. However, with my taking on additional duties from probate involving emergency conservatorships and emergency limited fiduciaries in healthcare situations, we're hearing medical malpractice that are more significant cases because the amount of discovery involved. I am hearing motions still. We've not stopped at all since they started the, I guess, what was it, March 9th. We've heard motions by telephone, like on a Wednesday. Bill, who has stayed in the office, will contact everyone on the civil docket to see if the matter's contested, to inform them what the dial-in number is for the telephonic bridge, which is for what used to be known as a party line when I was a younger person. So actually on our motions have where everybody can hear what's being said, which I think is in keeping with keeping the courtroom public. On the impaired driving dockets, put that on hold. We had hoped to resume in May 15th or 14th, I believe, but with the Supreme Court extending the no contact, even though we had thought we could do it in a manner that really minimized contact, we will roll all driving dockets that were to occur in May to start for 2 days during what would have been judicial conference in June, but was canceled. And my hope there is because of the thing we'll be able to accomplish in the hallway, we at least won't be interfering with other courts conducting business, since it was a week that we were supposed to be gone anyway. So the only thing I'm doing now on criminal matters or bond reductions, I for probation violations. So all of that's done telephonically. We all rotate Middle Tennessee mental health. I've done that on WebEx, and it went very smoothly. That's the sort of thing that you just have to see the witnesses in order, in my thought, to really make a decision. I've been very busy with matters that have been assigned to me, which is, as I said earlier, the emergency conservatorships and the emergency limited healthcare fiduciaries. They are ones that are very strict on their guidelines in terms of time. Both are initiated with an ex parte petition under, I think y'all know about the notary requirements changing. Then I sign an order setting an appropriateness hearing. I appoint an attorney ad litem. And then within 5 business days of that order, appointing someone on an ex parte emergency basis, I have within 60 days of that initial filing or initial order, I have to do something to conclude it or it just expires. So we've been very busy, and with the exception of Good Friday and this past Monday, I've been having hearings pretty much every morning, but we've been doing it through the bridge, and it's worked well. I was just actually hearing one when I had to stop, and we rearranged till tomorrow because we were receiving testimony from medical persons. So it's still busy, but I miss the camaraderie, and I miss personally going to the courthouse and seeing my.
So for the emergency proceedings that you've mentioned, are all of those happening by the telephone conference, or are you
Yes, we're
handling
doing,
anything?
thus far, it has worked by bridge. If anything on those matters, because I'm dealing with more, well, it's just the nature of the proceedings. I can actually hear a lot in the voices of the people who testify. Many times they're not really contentious. I mean, but the one I'm dealing with this morning and continues tomorrow has been somewhat contentious, has been satisfied with the telephonic bridge. But I'm open. Someone wants to have something done by Zoom or WebEx, we can do that. Our IT does not support Zoom. They do WebEx, the IT does, but I've even done FaceTime. So I've been very flexible. So it's whichever way. The only problem, like today we had for the first time, someone raised the issue of asking for the rule. So that's something of an issue. I mean, it's good if the attorney is in the room with the witness that is not a part and they go outside and don't hear it. But in this circumstance, in Minnesota and then another person in Colorado, so we just had to really make certain that they hung up. But, so there was a little bit of an honor system there. So, so that was the first time I've had difficulty on that in terms of the rule being invoked during a contested hearing.
You mentioned that you're still hearing motions on your civil docket. Do you anticipate there being any backlog on that docket at all? I'm sure you've moved to jury trials. I know one of mine has.
Oh, well, the Supreme Court has said no jury trials till July 3rd, which of course July 4th is the next. I think we only have 1 week set aside for jury trials in July. We do the rotation and things. I think a lot of this is just going to be see how things go. I cannot imagine at this point anyone showing up to the jury trial. I think they would be scared. Hopefully things will relax, etc. But on the motions, I not received any indication that people aren't having their motions heard because I'm hearing telephonic. I mean, we've been hearing the motions. So, we have the normal number of continuances. We've had to continue a lot of non-jury cases, catching up the non-jury when we do resume, which I would suspect we will probably be to resume non-jury, I would suspect in June. But the jury trials have definitely been postponed until July.
In terms of scheduling orders and case management,
yes.
How are you handling deadlines for depositions and whether they need to be taken in person or by video or telephone?
I think for 23 years, and I've only had to take one deposition during that 23 years remotely, and I didn't like it. I like seeing my witnesses and assessing them. If there is a deadline for depositions to be concluded, I would work with the parties because I think that's just part of confrontation and assessing credibility of witnesses is to take depositions in person. And I think more if the case is involved in case management, she would work also. I can't think of a better argument than a pandemic to extend everything.
I have a question from a member of our audience about jury trials that have been rescheduled that were originally set to occur in March, April, May, and beyond. When those trials are rescheduled, will they be bumped after currently scheduled trials in, say, August, September, and October, or will you shift the entire calendar?
Well, that would be more of a Marsh question. I would assume if it's a malpractice or something that's a very complicated, that would take priority. But that would be a Marsh-Nichols question. And what we are doing now, and I'll tell you, if someone wants to have a non-jury trial now, and have a non-jury trial remotely through videos or WebEx. I was just speaking with all the circuit court judges yesterday afternoon, and we're all willing, without being in rotation, to handle that is assigned to our specific court if the parties can agree that it be in rotation. But in terms of your question, which is about the priority of cases set back further or bumped, I'm not even aware that Marsh has reset any of those that have been bumped. I thought continued. So I really, we need her input on that, because I generally don't set any of my cases. I just say it's about the dates available. I'm told where to be.
When the court does resume in-person motion hearings and in-person proceedings, what sorts of measures do you anticipate putting into place to ensure social distancing?
I might be someone that's going to be a little bit more extreme. Judge Fishburne met the health department person yesterday that is the head of Mayor Cooper's task force. They're recommending that we even have temperatures checked coming into the courthouse, which I wanted to do 2 months ago, and we would have the guards do it, masks, hand sanitizers. I don't know if Metro is going to get the resources to do that. It would make sense to me to approach it on a building-wise basis rather than relying on each court doing that sort of measure, because and you don't test them or stop them at the checkpoint when they come in, then they've gone up the elevator, they've walked through the hallways, and that just really doesn't make sense. We have been given the option of having some plexiglass installed, like for instance on either side of the podium. The attorneys, and this was primarily for the impaired driving dockets, attorneys and public defenders on either side would have some physical barrier between them and the person speaking. I will have plexiglass installed for once again, it's primarily the impaired driving docket. Sit to my left, which are the docketing clerks, because people tend to crowd up on her, Miss Williams. I have ordered for our use the touchless infrared thermometers. We've also, I ordered that back in early. It didn't come. Its second order's been placed. It hasn't come. Been placed, and it's supposed to come in by the 20th. So if Metro doesn't scan down at the checkpoints coming in, then we will very possibly consider doing. Will encourage attorneys to wear face masks if it's not a mandatory thing in the building. Clients, for their own safety, I would suggest that they encourage them to wear face masks. I mean, the face mask really doesn't protect you as much as it does protect those around you. So, I mean, I think the better course of action might be, this sounds paranoid, I'm going to assume everybody has it, and that everybody in the court, an underlying medical reason that if they have, received the virus, that they might have more dire consequences as a result. Not a responsible way, because none of this is worth dying for. And I think we have to establish the rules in order to protect everyone that's participating. So I don't know, I've gone too far.
No, that's exactly what I was looking for. And one other question that I've heard a lot is, once we are back to having in-person proceedings, will you continue to allow lawyers and litigants who prefer not to appear in person to appear by phone or video conference?
Absolutely. I think it's been, I mean, from the perspective of just saving money for paying for an attorney to go downtown, no, absolutely. If and this is assuming when the Supreme Court lifts and says we can start doing in person, then if both sides agree, I'll do it. I'll do it by bridge. I'll be glad to do it by WebEx, just any which way. I think I've actually enjoyed it, and I found the attorneys to be a little bit more relaxed on the telephone. So I think it's a positive thing, a good change that might be coming around in that regard.
Speaking of attorneys being more relaxed, there have been some news stories recently about lawyers, I think in Florida, who have appeared in inappropriate attire, or I think there was one where an attorney appeared lying in their bed. Do
How
you,
funny.
I was going to say, do you have any tips for attorneys that are appearing by video or telephone? And do you have any
I think
stories?
dress like you would be going to court. I'll be wearing, if I'm doing a video conference, I'm going to be dressed like I would be on the bench or in my office in chambers. It shows respect for everyone. It maintains, I think, a professional attitude. I mean, obviously, when we're doing a telephonic or a bridge hearing, I have no way of knowing. And yeah, I'm quite frankly, if everyone acts professionally, I don't really much care. But the judges yesterday were having a conference at the kitchen table. They thought it was a little bit much. Judge Jones says that he puts on his robe even if it's a telephonic hearing. I can't make the same promise. So
It's sort of like when they say to smile when you answer the phone because it communicates.
yeah, that's true. It makes you sound like you're at more pleasant voice.
I'm going to take a quick pause just to remind everybody on this call, if you have a question for Judge McClendon, if you'll use the chat function at the bottom of your screen, I'll be sure to ask your question. Judge McClendon, the most recent order from the Tennessee Supreme Court allows judicial districts to come up with a plan for resuming in-person hearings sooner. Do you anticipate that our judicial district will submit a plan like that? What insight can you give us?
Judge Binkley's already been working on it, and that was part of our discussion yesterday afternoon at 3:00. The way, because we have such a variety, the criminal court judges are coming up with their plan, and I believe I can't remember if Judge Fishburne's drafting that or Judge Jennifer Smith, but it would be with all of their agreement. Same thing with Sessions. Linda Jones is in charge of that, and I think she got 8 judges out of 11 to agree to a plan. So I assume the majority wins on that. I don't know what those plans are. Domestic will come up with their plan. Chancery, Pat Moskell's drafting what they agree to, and I would assume juvenile court. So technically, Judge Binkley is the presiding judge of 20th Judicial District. So he will be submitted. So that absolutely, it will be submitted. I don't know what the deadline is. And quite frankly, we all agreed that regardless of what the overall plan will be, in the interim, barring having in-person hearings such as ex parte orders of protection and those where due process might be an issue, we will kind of use our own discretion. I mean, none of us are going to have a jury trial, but if people want to have a trial remotely.
Are there any changes that you have seen come out of this pandemic that you think the courts will adopt in the future, even once we're out of the woods?
I think that the use of conferencing will possibly increase. I would like to see it increase. I don't want to sound like paranoia, but I can only think that there will be other possible viruses that come in the future. So we should always maintain the distance, even though I don't much care for it. I'm a bit of a hugger and a handshaker. But I think the positive will be being able to do the conferences and hearing. I think that will be very much a positive. A lot of time, and it's to maintain a little bit of distance.
I have another question from one of the members of our audience. And the question is, you're presiding over emergency conservatorships and emergency limited fiduciary hearings, and that would
Yes.
seem particularly difficult to handle as a judge. You already mentioned the strict statutory time constraints. Can you talk
Yes.
about your experience in dealing with these cases in contrast to the other civil cases?
Other civil cases? Well, other civil cases, you can always bump and roll if there's an issue with a witness or something. Um, as I said earlier, it's considering that I have not been at the courthouse very much. I've been very busy. The way we're handling it, the attorney, we only have one staff member working in the office, and he's been primarily dealing with these emergency matters. People are working remotely on entering orders and that sort of thing. And so Bill Britt will receive an inquiry, then he will ask them to email it to him. He will then in turn get it. He lives close to me. And I'll read it, sign off on ex parte order. We have to choose a day. So we're hearing, like I said, with the exception of Good Friday and this past, like yesterday, Monday, we've had hearings every day. So we do the ex parte on the sworn pleading, appoint the attorney ad litem, the 5-day appropriateness hearing, and that's 5 business days. Now, if something really strange happens, then there's some emergency powers, there's a statute that I can utilize to push it just a little bit if I go through and state reason. But I can only remember one that we've done during this 6 or 7 week period, and it was because we were unable to get a physician to testify on the telephone. And it turned out, in fact, Vanderbilt had a policy against residents giving their opinions on the form regarding opinions. So we did go outside of the 5 days on that for the appropriateness. The 60-day hearings, it doesn't mean it has to be at 60 days. It could be shorter than 60 days. So that has not been a problem. We tend to put the 60-day hearings on Thursdays. We've also been doing that by bridge. Sometimes I've had a couple where really wanted to see if the person might get better, and it had been converted to a conservatorship, and we've set up reviews after the conservatorship has been established. So funny enough though, my statistic, what I've concluded, it'll only show the ones that have converted to a conservatorship, a permanent conservatorship. It doesn't show what's occurred prior to that. Much like in many civil cases, you don't see the summary judgments as a statistic. You don't see the motions to compel. It's just showing that you concluded a case. So, but I've enjoyed it. It's a great group of attorneys. Very, our most difficulty is finding attorneys, because when we get the petition, setting forth the need for is finding someone immediately that can do the attorney ad litem. And we try to, that, if we don't have cell phone numbers, and we've tried to get everybody's cell, if they don't answer, we can voicemail, we move on and ask the next person. So if you're interested in receiving those appointments, the ones on I think Judge Kennedy called ELFs, they're paid for, the attorney's fees are paid for by the hospitals. So it can be an area of practice. So if you want those, if you see the number coming from Metro, you need to answer the phone, because when the person doesn't answer, you need to get someone appointed immediately.
And for any attorney who maybe hasn't received appointments but is used to receiving those, is there a way they can communicate their cell phone number and contact information?
Oh, absolutely. I had Miss Wiley go through all of our list and talk to them. There were some attorneys that might have health issues that would prohibit them from going into the nursing homes. And quite frankly, the nursing homes, if they come out of the nursing homes, they have not been allowed to go in there. They have to do it by video chat, and that nursing home. So I would suggest, if you're interested in these appointments, the Second Circuit office, and speak to Mr. Britt, Bill Britt. He has a list, and we'll appoint you. Now, the person who files usually has the fiduciary in mind. So that part is usually taken. There are some situations where I think maybe there's a conflict involved with the person who wants to be appointed, it maybe family member or someone that there's contentious issues somewhere that are unnecessary and detract from the true issue, which is the welfare of the respondent. The fiduciary is appointed, but typically the petitioner will propose a fiduciary. I have the control over the attorney ad litem, and it's been rare for me to appoint an attorney ad litem and a guardian ad litem, but I can also do that.
I have a couple of questions that are on this same topic, and you actually just mentioned the trouble with meeting with the ward in the
Yes.
nursing home.
Uh-huh.
So one of the questions from our gallery is how you're handling service on the respondent if they're in a nursing home and you can't get in. And then the second question is just, have there been issues with attorneys being able to meet in person with the proposed ward?
No one has told me that they've had difficulty. I've all meeting in person though. I believe what is occurring is they are meeting through telephone, they are meeting through video with the respondent. And the hospitals, they've had more success getting in and just meeting face to face. Attorneys have, no one yet has stated they feel forward under the circumstances of really having to the manner in which they communicate. And really the only restriction has been face-to-face aspect, which if they can do it by video conference or by telephone, and I think they feel comfortable with that. Yet it's actually been, for the most part, clear cut with the exception of the ones that I'm having.
And I'm sorry, you cut out just a minute, just for a couple of seconds there. Did you address how you're handling service on the respondents?
Oh, on the service, it's interesting. Really, the petitioner ought to be the person that serves. The attorney, it just, how can the person consent to the attorney receiving? So I think the petitioner needs to serve. And thus far, once again, we have not had issues with the petitioner getting service to occur. I don't know if it's being taken in and delivered by someone in the nursing. In the hospitals, it's not been an issue at all.
I'm going to take one more pause because we're coming towards the end of our time. And just to remind everybody on the call, if you have a question, go ahead and send it out through the group chat function at the bottom of your screen. I have more questions for you, Judge McClendon. Don't worry. I just like to give everybody a heads up so we get all the necessary questions asked. We talked a little bit about our judicial district coming up with a plan for having in-person hearings. I'm just curious, kind of on a more broader scale, what kind of communication have you had with other courts in our state, with the Supreme Court, and just in our own judicial district about the issues that are coming up?
We've had the Supreme Court nearly weekly conference calls, which that's a heck of we're talking 180 people on a basically a chat line at the same time. And it's been really, I think, everybody working through and brainstorming the legalities and interpreting the court's orders. Same sort of thing occur with the judges here locally. Once again, we do have different needs. I mean, criminal obviously has more need for due process, aware of speedy trial issues. In domestic court, they have to have their primary concern has been the ex parte orders being acted on in the 15 days. So there's been discussions occurring formally, and there's been informal discussions through text, that sort of opinions on things. Supreme Court's been excellent, and I think have made very judicious and very wise decisions, and actually been a little bit more conservative than I think a lot of people expect them to be. But I think the welfare of the litigants and the attorneys and our staff has been very much on their minds, and they've acted very responsibly. Pair of driving dockets set to start in May. I think we had 4 set, and I was starting to get very nervous about it. So I was really happy when yesterday they announced that the restriction on in-person would continue until June 1st. That made me very happy. So we've rolled all of ours to occur in June on those dockets.
Is there anything that's been easier because of this interesting time that you're going to miss when we go back to the normal course?
No, I don't think so. I've actually felt very lost not being in more of a regimented situation of dockets and being at the courthouse and everything. Decided probably the better way is for me to stay away from the courthouse for the most part, and that will being Mr. Britt being the only one in the office, there's no contamination being brought in. Sanitizers, he doesn't let anyone in. We don't even let the cleaning ladies in because we thought, they might be going from office to office. And so we thought it was better to kind of isolate and handle everything remote. So I do very much in socializing as you do when you're working. And I miss having courts. But the good thing out of this, I think, being able to become more familiar with the technology that's available for the remote access hearings, and I can't remember, Judge Brothers has come up with a fancy word for that, but that is. I welcome that as another tool to make the courts available to people, especially if you think about the number of witnesses and elderly participants that perhaps just really getting into the courthouse downtown is a big effort for them. So this will be something that's available.
Is there anything else that lawyers and litigants in your courtroom need to know about procedures during this time and how the court is handling different matters?
When in doubt, call and ask Mr. Britt. Now, something I had that just happened recently with one of the, it was an emergency conservatorship. They filed, and there was a need for the one of the petitions, a translator, and I mean, he had no note. That we were on the appropriateness hearing. We had not. The attorney would obviously have knowledge of whether his client needed an interpreter, so it had to be continued for that purpose. You can't hardly get an interpreter right now that's appointed like through Christina Frazier, who is normally available for us. They just can't. They just can't do it right. Having to allow. So if you have a client that needs an interpreter, I would call and talk to the judge of the court in which it's occurring, and have any objection to a interpreting or a friend interpreting. But it's just frustrating for everyone for that to be brought up at the last moment. It's just time. And just be aware, Christina Frazier cannot get interpreters right now.
And you've mentioned Mr. Britt a few times during the course of this conference. Is his contact information available on the website through your chamber's rules?
Well, it's the 862-5905, and I think if you ask him for his cell phone, he's pretty liberal about giving it out. But I give it out. But he's been there every day, and he's usually there till 2:00 at least, and then often he'll forward numbers to himself. So he's a very cordial man. I'd say just call him and ask for a cell in case you need him on an emergency basis. And we've been able to get things signed the same day. It's actually, if anything, actually working in a more smooth manner than we did when we were all in the courthouse. Maybe because we're making the extra effort, maybe because we can focus better on the job at hand rather than chit-chatting and being distracted by personalities and that sort of thing.
On your motion dockets, are you having them start at the normal time, or are you
Yes.
kind of staggering them?
We like I said, we know in advance which ones are going forward. I receive the docket, and the ones that I need to read, Thursday afternoon. Um, then we have it at 9. And typically in advance, I kind of know from reading it which ones are the simpler ones to take. So I'll tell Mr. Britt, bring up number 3 first, do so-and-so, do so-and-so. Go ahead and do it in that order. Everyone can hear what's being argued. I feel like that is kind of in keeping with having an open court. If we have something that's extraordinarily for later in the day, or say, okay, y'all need to call in 11, sometimes we will have other matters heard at different times, such as if we have a probate matter that, like a motion or a petition to sell real estate, we'll hear that later in the day. So it's been fun. On civil motions, we're hearing them at 9 o'clock.
Well, Judge McClendon, I think those are all the questions that we have from our audience members and all the questions I have today. We thank you so much for being with us. And
well, thank you. It's I've enjoyed it.
And we look forward to seeing you in person again soon. And thank you to everyone who participated in this conference. And
Laura, thank you so much for all the hard work you're doing. I know you say that it's been sort of a lot of additional work for you.
Well, I'm happy to do it. Thank you, Judge McClendon. And now we'll bring this to a close.
Be safe. Thank you.
Thank you.